Hello friends, today let's discuss about agreements in restraint of trade. Imagine someone offers you 1 lakh but only if you promise never to get married. Can that agreement hold up in the court of law? The Indian Contract Act says that it's absolutely not possible. The law protects our personal choices to marry somebody or not to marry somebody. This rule is embedded in section 26 of Indian Contract Act. First, I'll go forward with the introduction. Then I will discuss the position of agreements in restraint of marriage under the English law. And then I will discuss about the position of agreements in restraint of marriage under Indian law. And then I will briefly compare brokerage agreements and betrothal agreements. And then I will discuss the exception. Last but not the least, I'll be concluding my lecture. Marriage, as we all know, is a social institution which is of great importance, and thus the law protects any form of interference upon the institution of marriage. Section 26 of Indian Contract Act declares that every agreement in restraint of marriage is void. Do bear in mind that both complete restraint as well as partial restraints are recognized as void under Section 26. The underlying idea is that the freedom to marry is a fundamental personal right, and any attempt to restrict or control goes against public policy. Only one exception exists: agreements restraining the marriage of minors. As such, restraints align with the law against child marriage. The Indian Contract Act, under Section 26, embodies the principle that personal liberty, especially the freedom to marry, cannot be curtailed by private agreements. Right to marry is a fundamental right under Article 21, which talks about right to life. Section 26 of Indian Contract Act reads as follows: every agreement in restraint of marriage of any person other than a minor is void. Thus, if there are agreements which prevent, discourage, and restrain someone from getting married to somebody, then that is something which is prohibited under the section 26. So, if at all there is a condition that to inherit the family property, one has to not get married at all, then that acts as a complete restraint. Let us suppose that there is Mr. X who wants to stop his daughter from marrying somebody outside the caste. That will act as a partial restraint. Let us look at the position of agreements in restraint of trade under English law. Under the English law, partial restraints have been recognized. For example, if there is a condition preventing somebody to marry a specific person, then that can be considered to be partial restraint. Meaning, A, that is the father, leaves property to his daughter provided she does not marry X. This is a partial restraint, and this has been recognized as valid under the English law. In Lowy versus Pierce, Pierce had made a written promise to the plaintiff Lowy that if you shall marry any person other than me, you shall pay me £1,000 within 3 months of such marriage. Essentially, it was held that the defendant would not marry anyone else, and if he did, he would pay £1,000 as a penalty. Later, Pierce married another woman, and Louis sued him for breach of promise. The issue before the court was whether the written promise by the defendant not to marry anyone else was valid and enforceable contract. The court held that the agreement was void. The reasoning given by the court was that agreements which restrain marriage are against public policy. Any contract that curtails a person's individual freedom and liberty was lawfully void as well as unenforceable. It was also enunciated in the case that no damages could be claimed for breach of such a contract. Similar principles were followed even in Hartley versus Rice. The defendant, Rice, had promised the plaintiff, Hartley, a sum of money on the condition that she did not marry a certain person. Later, the plaintiff claimed the payment under that promise. The defendant refused to pay, arguing that the agreement itself was void. Was the promise to pay money in restraint of marriage valid and enforceable? The court held that the agreement was void. The reasoning given by the court was that any agreement that restrains a person's freedom to marry is against public policy. Marriage is considered beneficial to the society, and the law will not enforce promises that discourage or prevent marriage. The object of agreement was immoral and contrary to the public policy. Now let us discuss about brokerage agreements. So basically here there will be a broker involved for the purpose of fixing the alliance between the girl and the boy's family. So those are the agreements which will be considered unlawful under section 23 of Indian Contract Act. The key difference between the English law as well as the Indian law is that the English law permits partial restraints, while the Indian law declares all restraints, whether absolute or partial, as void. Under the Indian law, both agreements which act as complete restraint as well as agreements which act as partial restraints have been declared as void. Marriage is a personal right. Moreover, right to marry is a fundamental right within the ambit of Article 21 of Indian Constitution, which guarantees right to life. There is freedom upon a person to marry anyone, and that freedom should not be curtailed by the state. That is why there is a law which is protecting Indians under the Indian Contract Act. Now, let us look at both brokerage agreements as well as betrothal agreements. Marriage brokerage agreements are considered void under Section 23 of Indian Contract Act. For an illustration, A agrees to pay B 50,000 if B finds a suitable bride for A. That is a brokerage agreement. So, in the olden days, brokers were the ones who would bring forward the alliance between the girl and the boy's family. So, the law recognizes that if there are brokerage agreements involved and if they are questioned before the court of law, they will be considered to be void. Any opportunity to enforce such agreements are considered void. In Ramanatha Chettiar versus S.M. Annamalai, a promise to pay commission for arranging a marriage was held void. The court held that such agreements are immoral and contrary to public policy. In Chettiappa versus S.N. Rajan, it was held that any payment or reward for marriage negotiation invalidates the agreement. A betrothal agreement is nothing but an agreement where there will be a mutual promise to marry each other in future. In Khushal Chand versus Lakshmi Bai, it was held that an agreement to marry somebody in future is not enforceable. The court will never grant specific performance of such agreements, although it has not recognized them as void. In Hirani versus Ramdasi, it was held that if there are expenses incurred based on a promise to marry somebody in the future, no action will lie for damages. Although these agreements have not been explicitly declared as void, agreements such as betrothal agreements cannot be enforced before the court of law. In Abdul Qadir versus Salima, it was held that social or religious agreements are unenforceable and betrothal agreements fall under that category. Let us look into few case laws regarding Section 26 under the Indian Contract Act. The first one is Abbas Khan and another versus Noor Khan. In this case, before the Lahore High Court, a Muslim woman had married a man without the consent of her nearest male relative. As part of the custom, the Pathan community recognized that if a woman married somebody without seeking the nearest male relative's permission, the man had to pay bride price, which was recognized as a custom prevalent in the community. It was held that such a custom was acting as a restraint upon marriage, and moreover, the custom was held to be immoral and against public policy. In Air India and others versus Nargis Mirza and others, the air hostesses were put in certain conditions, such as they would retire from the services in case of following contingencies, that is, on attaining the age of 35, on marriage if it took place within 4 years of service, and on first pregnancy. The Supreme Court directed the companies to change their regulations to bring parity in the retirement age of the air hostesses, and moreover, it struck down the rule against first pregnancy, finding it in violation of Article 14 of Indian Constitution. However, it has to be noted that there is a violation of Section 26 of Indian Contract Act, wherein the rules restricted the air hostesses from getting married. In Rao Rani versus Gulab Rani, a division bench of Allahabad High Court looked into this case wherein the parties were widows of the same man, Ram Adar. After the death of their common husband, a dispute had arisen at the revenue court regarding the matter as to who would inherit a certain zamindari land holdings. But the dispute was settled amicably by the widows, wherein they entered into a compromise, wherein both of them would inherit equally, and if any other ended up marrying, the entire property would shift to the other. Subsequently, Gulab Rani married again, and the property came under the complete control of Rao Rani. Later, Gulab Rani filed a suit to regain ownership of part of the property and claimed that the compromise deed was in void of Section 26 of Indian Contract Act, which was acting as a restraint upon marriage. The High Court expressed its doubt on whether Section 26 of Indian Contract Act encompassed partial or indirect restraint on marriage, and it was not persuaded by this argument. Chief Justice Ahmed stated that all that was provided was that if a widow elected to remarry, she would be deprived of her rights given to her by the compromise. In other words, no direct prohibition to remarry was imposed by the compromise. The compromise was arrived at in order to preserve the family properties and to ensure proper management. Let us now look into the exception. Under Section 26, agreements which act as restraint upon marriage of minors are considered valid. There have been recommendations to recognize partial restraints as being valid. Example for reasonable partial restraints can be restricting marriage until the completion of higher education, allowing marriage only after a person attains certain position in the society. All these can be restraints which can be recognized as valid under the Section 26 of Indian Contract Act. The circumstances are changing, and moreover, you can always debate and discuss about prenuptial agreements, whether they are valid under Section 26 or not. Thus, I would like to conclude by stating that agreements in restraint of marriage, both complete as well as partial restraints, are void. There is a need to recognize partial restraints as valid under the Indian law. I have discussed and debated regarding betrothal agreements as well as brokerage agreements. Do let me know in the comments what do you think about prenuptial agreements and whether they can be considered valid under the Section 26 of Indian Contract Act or not. Thank you for listening to my lecture.